Welcome everyone to SQE1 window. Here we go with chapter 10 of our SQE1 criminal litigation. So today we are examining youth justice and costs in criminal proceeding. Youth justice operates differently from adult criminal justice system, reflecting the distinct needs and vulnerabilities of children and young people. Understanding these differences is essential for proper representation and compliance with statutory obligations. So we'll cover costs and compensation, financial aspects that conclude criminal cases. Part 1 focuses on youth justice principles, procedure and disposals. Part 2 addresses cost, compensation and legal aid. So both of them are a bit different, but we have just to condense everything to not haunt you or scare you from criminal litigation. We have just condensed all of them together. So yeah, we will talk about them one by one, and I'll try to signpost you where you are so that it does not mix up. So to start with, youth justice uses a specific terminology based on precise age categories. Understanding these terms is essential because they determine jurisdiction and sentencing powers. First, juvenile means anyone under 18 years of age. This is the broadest category, encompassing all young offenders below adult age. So, second, child means anyone under 14 years of age. This narrower category attracts additional protection and restriction. Third, young persons mean someone aged 14 through 17 inclusive. So there is still they are still juveniles but distinguished from children for sentencing purposes. So why do these distinction matters? Sentencing powers differ significantly between 10 to 13 years old and 14 to 17 years old. So some sentences are only available for young persons, not children. Some require different threshold depending on age. So classification affects procedure too. How courts address young defendants, what safeguards apply, and what support must be provided all vary by age. So that's why it is important. So age of criminal responsibility, that's what you should keep in mind, is 10 years in England and Wales. Below this age, children cannot be prosecuted regardless of what they have allegedly done. So in exam, it can ask which label applies and why it is important. When you see a scenario, immediately identify whether the defendant is a child or young person. This classification drives your entire analysis and answer to the question. So, Crime and Disorder Act 1998, Section 37 establishes the overreaching aim of youth justice system. The aim is fundamental and must be stated in every youth justice answer. So statutory aim is preventing offending and reoffending by children and young people. Everything in youth justice serves this preventive goal. So it's not punishment, it is prevention. So this aim creates a duty on everyone exercising youth justice function: police making decisions about youth suspects, Crown Prosecution Services deciding charges, defense counsel advising clients, and courts determining sentencing. All must regard this statutory aim, and that is prevention. So local authority participants are also bound: youth offending teams, social services, education authorities. Anyone involved in youth justice must work towards preventing offending and reoffending. So once again, it is not punishment, it is prevention. So the statutory aim acts as a lens for decisions throughout the case. Should this young person be charged? What's the appropriate sentence? How can we address underlying causes of offending? All these questions must be answered with prevention in mind. So this does not mean being soft on youth crime. Prevention often requires intervention, accountability and consequences. But it means choosing interventions designed to stop future offending rather than simply punishing past conduct. So in exam, it can trigger, your exam trigger can be like, state the aim and identify who must regard it. It's in every youth justice answer, articulate this statutory aim and show how it influences decision. So welfare principle. So beyond the statutory aim, the welfare principle from the Children and Young Persons Act 1933, Section 44, requires court to regard the child's welfare when dealing with juvenile order offenders. So courts must balance punishment with welfare consideration and the young person's proper development. This means asking what outcome best serves this young person's long-term interest whilst holding them accountable. So the principle requires removing young people from undesirable surroundings where proper. If home circumstances contribute to offending, the court can intervene to protect welfare. So courts must also secure proper education and training provisions. So young people need skills and opportunities to move away from offending. Importantly, this principle applies whether the young person is before the court as an offender or otherwise. Welfare always matters when courts deal with children. The welfare principle does not override punishment or accountability. It complements them. The question becomes, how can we punish appropriately whilst also promoting welfare and preventing future offending? And that's the prime objective of all those punishments. So your exam trigger can be, how does welfare change the disposal? When analyzing sentencing scenarios, explain how welfare consideration might lead to different outcomes than for adult offenders. So perhaps custody is inappropriate despite seriousness because welfare demands community interventions. So the next thing is parental responsibility. Parental responsibility is legally defined in Children Act 1989, Section 3, as all the rights, duties, powers, responsibilities, and authority that parents have by law in relation to the child and their property. The broad definition covers daily care decisions, medical consent, education choices, discipline, and representing the child's interest, like parental responsibility matters in youth justice because courts involve those with parental responsibilities throughout proceeding. Who holds parental responsibility? Married parents automatically share parental responsibility for their children. An unmarried mother has automatic parental responsibility. An unmarried father can acquire parental responsibility through various mechanisms, being registered on the birth certificate, parental responsibility agreement, or court order. So local authorities may share parental responsibility through care orders or other statutory provisions. When this occurs, both parents and the local authority have responsibilities. Though local authorities can restrict parental exercise in certain circumstances. So understanding who holds parental responsibility is essential because these individuals must be notified, can attend court, and bear certain obligations, including binding over orders and contribution to financial penalties. So in exam, identify who holds parental responsibility, look at family composition and determine who has parental responsibility, and this affects their role in proceeding as well. So let's talk about paying for youth legal representation. So legal aid rules for young people ensure access to justice regardless of financial means. At the police station, advice and assistance are completely free under the duty solicitor scheme. No means test, no contribution. Young people get free legal advice when detained or questioned by police. Post-charge, defendants need representation order covering magistrate court and crown court proceeding. For defendants under 18, both the means and interest of justice test are automatically satisfied. They don't need to prove financial hardship or justify any representation is necessary. The automatic qualification ensures that all young people can access proper legal representation throughout criminal proceedings. Financial barriers cannot prevent effective defense. So, however, application must still be made. Automatic qualification does not mean automatic grant. Someone must actually apply for the representation order. Apply immediately after charge to avoid delays. So in exam, the question can ask you, do under 18 automatically qualify for legal aid? Yes, for representation order. Both mean and interest tests are automatically satisfied. But remember, police station advice is free for everyone, not just under 18. Everyone gets free legal advice at police station. So, turning 18 before proceeding, age at key moment determines jurisdiction and procedure. Let's examine what happens when defendant turns 18 at different stages. And that's very important. If the defendant was charged while under 18 but turns 18 before entering a plea at first hearing, the youth court loses jurisdiction. Commencement means the first hearing where plea is entered, not charge date. So the case must be remitted to the adult magistrate court. The youth court cannot continue and it no longer has jurisdiction once the defendant turns 18 before proceeding can commence. For indictable only offences, the adult magistrate court sends the case to Crown Court following normal adult procedure. So for remission onward, the defendant is treated as an adult offender. Adult sentencing power apply, adult procedures govern, and youth disposal become unavailable. So this timing rule can significantly affect outcome. So a defendant charged at 17 years and 11 months who turns 18 before first appearance faces adult court and potentially harsher sentences than if proceeding had commenced while still 17. So understanding what commencement means is crucial. It's not offense date or charge date. It's first hearing where plea is entered. So in exam, define commencement and its effect. That's what you need to keep in mind. So, if proceeding commences while the defendant is under 18, but they turn 18 during the case, different rules apply. The youth court has discretion. The youth court may continue dealing with the case despite the defendant now being 18. Alternatively, the court may remit to adult magistrate court. This is discretionary decision based on what's appropriate. So, if the youth court retains jurisdiction, youth disposal remains available, the court can impose a referral order, youth rehabilitation order, or detention and training order, even though the defendant is now 18. Age at commencement determines available sentences. This is significant. Keeping a case in youth court after turning 18 means access to youth-focused intervention designed for development and prevention rather than purely punitive adult sentences. So mode of trial is fixed at commencement. If the case was suitable for youth court when proceeding began, it remains so despite the defendant aging out during proceeding. So it remains so, it does not change anything. So in your exam, the question can ask, can youth court keep cases post 18? Yes, discretionary. If retained, youth sentences remains available because age at commencement governs disposal options. Remission consequences and election. When a case is remitted to adult magistrate court, several consequences follow that effect. The defendant's rights and the case trajectory, everything changes. For either way offense, the now adult defendant gains the right to elect Crown Court trial. Youth courts don't allow election, but adult magistrate courts can, and this right emerges upon remission. For indictable only offences, the adult magistrate court sends the case to Crown Court following standard adult procedures. So this is mandatory, not discretionary. Importantly, there is no appeal against remission order. The youth court's decision to remit cannot be challenged. It's within their discretion, and that's final. So remitting court adjourns proceeding rather than continuing them. The case transfers entirely to the receiving court. The receiving court deals with the defendant as an adult offender. From that point onward, an adult sentencing powers apply. Adult sentencing guidelines govern and youth disposals are unavailable. So these consequences can be significant for defendant and their representative. Remission might mean harsher potential sentences, but also procedural rights like jury trial election that youth court does not offer. So after remission, what election right? For either way offences remitted to adult court, the defendant can elect Crown Court trial, a right unavailable in youth court. So, youth court composition. Youth court have distinct composition and access rules reflecting their different purpose and the need to protect young defendants. Most youth cases are tried in youth courts. Specialist magistrates court dealing exclusively with juveniles. The bench comprises up to 3 magistrates specially trained in youth justice. So magistrates are encouraged to sit at the same physical level as the defendant rather than on a raised platform as it is in courts, normal courts. This less formal arrangement reduces intimidation and promotes communication. So critically, youth courts are not open to public, unlike adult courts where anyone can attend. Youth courts restrict attendance to necessary parties and approved observers. And who can attend? The defendant, their family, legal representative, court staff, social worker, appropriate adults, and sometimes approved students or researchers. Journalists may attend but face reporting restrictions. So reporting restrictions protect young defendants' identities. Media cannot publish names, addresses, schools, or identifying details unless the court specifically lifts restriction. So these privacy measures recognize that young people's development should not be permanently harmed by publicity surrounding their offending. So the question can ask who can attend youth court and what reporting limits apply. So I hope you understand these from the slide we have explained. So youth court procedure mirrors adult magistrate court's procedure in many respects, but with adjustment for the defendant's age and understanding. If the young person denies the offense, trial procedure follows the same basic structure as adult magistrate's trial. Prosecution and defense present cases, witnesses testify, and the bench decides guilt. After a guilt plea or finding the guilt, the prosecution outlines the facts and presents the defendant's record about previous convictions or cautions. They may also request ancillary orders like compensation or cost. The defense then presents mitigation, explaining circumstances, highlighting positive factors, and arguing for lenient disposal. The young person themselves may address the court, and parents or guardians may also speak. Importantly, the bench actively inquires into the reason for offending, the impact on the victim, and the defendant's background and circumstances. Youth courts take a more investigative, less adversarial approach to understanding what led to offending. So this inquiry, serves the statutory aim, that is understanding causes, and that helps design interventions to prevent reoffending. Pre-sentence reports are frequently ordered, allowing youth offending team to assess the young person and recommend appropriate disposals. So in exam, it can ask what happens immediately before disposal. Prosecution outlines facts and records. Prosecution requests order. Defense mitigates. The bench inquires into background and reason, often ordering reports, all of it. So deferring sentence up to 6 months. Youth courts can defer sentencing for up to 6 months. This power allows court to test young people before imposing final sentences. Deferral is appropriate when there is an imminent, sufficient lifestyle change that might demonstrate rehabilitation. Perhaps the young person is starting education, employment, or training program. Deferral allows time to prove commitment. Deferral is also used when the young person needs a time to save money for victim compensation. Rather than imposing an immediate compensation order, the defendant cannot afford deferral or allows them to work and accumulate funds. During deferral, courts often impose conditions, maintaining good behavior, attending programs, or making progress towards rehabilitation goals. So compliance is monitored. After the deferral period expires, the court imposes a sentence based on the young person's conduct during deferral. Successful compliance leads to more lenient disposal. Breach or continued offending leads to stern consequences. So in exam, the questions may test when is deferral appropriate. It is appropriate when there is imminent lifestyle changes, saving for compensation, or testing compliance with conditions before final disposal. So referral orders are distinctive youth justice disposal designed around restorative justice principle. So understanding how they work is essential. A referral order refers the young person to a youth offender panel, that is YOP. This panel is not composed of magistrates or judges, but rather trained community members. The panel meets with the young person and their parents or guardian. These meetings are less formal than court. So designed to be constructive conversations about offending, impact and change. Together, they create a contract setting out interventions that a young person will undertake and ways they shall take responsibility for their actions. This might include reparation to victims, unpaid work, participation in programs addressing offending causes, or educational activities. Referral orders can be combined with compensation orders, allowing the court to address victim harm directly, whilst the YOP contract addresses rehabilitation. Importantly, there is no limit on the number of referral orders a young person can receive. Unlike some disposals that become unavailable after use, referral order can be imposed repeatedly if appropriate. The contract duration is typically between 3 and 12 months, depending on offense seriousness. So in exam, they can ask you to explain YOP contract and names. So you need to understand the contract is negotiated between the young person, panel, and family. And that sets out intervention designed to address offending causes and promote responsibility. So referral orders operate under mandatory and discretionary framework. Understanding which applies is frequently examined. Referral orders are mandatory when 3 conditions are met. First, the defendant is a first-time offender, no previous convictions or conditional discharges. Second, the defendant pleads guilty to the offense. Third, the offense is suitable for non-custodial disposal. The custody threshold is not crossed. When these conditions exist, the court must impose a referral order unless there are exceptional circumstances. This mandatory nature reflects the policy of giving first-time offender restorative justice opportunity so they can restore it back. So referral orders are discretionary in other situations. If the young person pleads guilty to at least one offense, but the mandatory condition are not met, so perhaps they have previous convictions or they pleaded not guilty, but they were convicted after trial, the court may impose referral order if appropriate. The court considers the defendant's age, offense seriousness, and previous convictions when exercising discretion. So length varies from 3 to 12 months depending on seriousness. More serious offending requires longer contract with more intensive interventions. So in exam, they can ask, is referral order compulsory here? So apply the 3 mandatory conditions. First offense, guilty plea, non-custodial suitability. So if all 3 exist, it's mandatory unless exceptional circumstances are there. So reparation orders are community disposals focusing specifically on making amends for offending. They are distinct from broader community supervision. Reparation orders are only available for imprisonable offenses. If the offense cannot result in imprisonment for adults, reparation orders cannot be imposed. This threshold requirement is strict. The purpose is confronting the offender with their actions' consequences. Reparation makes offending real and tangible rather than abstract. Reparation orders require unpaid work benefiting either the victim directly or the wider community. This might include repairing damage caused, working on community projects, or other constructive activities. The focus is reparation and responsibility, taking active steps to make amends rather than simply accepting passive punishment. So reparation orders differ from youth rehabilitation orders, which can include supervision, intervention programs, and various other requirements. So reparation orders are narrower, focused specifically on making amends through work. So in exam, it can ask, is the offense imprisonable? Yes or no? This is the gateway question for reparation order. Only imprisonable offenses qualify for reparation orders. So the next thing is youth rehabilitation order by RO. So they are the generic community sentence for under 18s, equivalent to adult community order, but tailored for young offender. A YRO must include one or more requirements selected from a statutory list that we got. The court tailors the order to the individual young person and their offending. So YRO pursue multiple aim: punishment, public protection, reparation to victim and community, and reducing future offending. These aims must be balanced. The threshold for imposing YRO is that offense seriousness warrants a community sentence. It's not appropriate for very minor offenses, better dealt with by fines and discharges, nor for extremely serious offenses requiring custody. So restrictions and requirement must be proportionate to offense seriousness. You cannot impose onerous requirement for family for the relatively minor offending. So proportionality is fundamental. So available requirement include activity requirement, supervision, unpaid work for 16 and 17-year-olds. Program requirement, drug treatment, mental health treatment, education requirement, and many others. So courts select combination appropriate to the young person's need. In exam, they can ask when the YRO available and proportionate, when seriousness warrants community disposal, too serious for fine or discharge, not serious enough for custody, and requirement match seriousness. So this is kind of middle ground for youth, putting them back to track or preventing them from committing more crimes. So let's examine YRO technical details: duration, prerequisites, bars, and requirements. Pre-sentence reports are usually required before imposing YRO. Keep in mind, the scaled approach helps assess appropriate intervention levels based on risk and need. So maximum YRO duration is 3 years. This lengthy maximum duration allows sustained intervention for serious or complex cases. YRO can be extended up to 6 months beyond the original term to allow the completion of requirement if the young person is making progress but needs additional time. So YRO are unavailable in certain circumstances. If a compulsory referral order applies, YRO cannot be imposed. Referral orders take precedence. If an existing YRO or reparation order is already in force, new YRO cannot be imposed until the existing order is dealt with. So available requirements are extensive. Activity requirements involve specified activities, supervision requirement with regular youth offending team contact, unpaid work for those aged 16 and 17. So program requirement addressing offending behavior, drug treatment requirement, other treatment requirement for mental health or other condition, and education requirement ensuring school or training attendance. So your exam, you need to understand spot YRO unavailability bars and list key requirements. So once you understand it, at that point, check whether compulsory referral order applies or existing orders prevent YRO. Then identify which requirement address this young person's need at that point for YRO. So another thing we got is detention and training order, DTO, and those are mean custodial sentence for young offenders. Understanding threshold, restriction and duration is crucial. The custody threshold must be met. The offence must be so serious that neither a fine alone or nor community sentence can be justified. This echoes adult custody threshold but applies specifically to juveniles. Courts must explain why RO with intensive supervision and surveillance or foster care placement are insufficient before imposing custody. This custody as last resort principle reflects welfare considerations. So age restrictions are strict. No DTO can be imposed on anyone under 12. They are below the age where detention is appropriate, regardless of offending. For those aged 12 to 14, DTOs required persistent offending. A single serious offense is not enough unless young person has a pattern of repeated offending. From 15 onward, DTO are available without persistent, requirement if the custody threshold is met. So DTO length must fall within set bands: 4 months, 6 months, 8 months, 10 months, 12 months, 18 months, or 24 months. So these are the only permissible terms. Courts cannot impose 5 months or 13 months. So all these durations are given where you can just impose DTO. So keep in mind all of them. So the next thing is DTO split and youth disposal. DTO have a distinctive two-part structure. Half the term is served in custody in secure youth institutions. The other half is served in the community under supervision. This structure balances punishment with rehabilitation. During the custody period, young people are held in specialized youth detention facilities, not adult prisons. These institutions emphasize education and development. The supervision period involves youth offending team oversight, conditions to comply with, and interventions addressing offending causes. Breach can result in recall to custody. So beyond referral orders, YROs and DTOs, other youth disposals exist for less serious cases. Fines are rare in youth courts because young people typically lack income. When imposed, parents or guardians usually pay. So compensation takes priority over fines when the young person cannot pay. Both victims' interest supersede punishment through financial penalty. So conditional discharge are available for up to 3 years. The young person is discharged without punishment on condition they don't reoffend during the specified period. So reoffending triggers resentencing for the original offense. Absolute discharges are reserved for very trivial offenses where conviction alone suffices. No further punishment is appropriate, but conviction is conviction. It's in itself, it denies a person from many openings in the life. So in exam you need to understand what is custody supervision split, half and half, 50% custody in youth detention and 50% community supervision. So this structure you need to understand. It has gone a bit lengthy session. So our favorite SQE tips and pitfalls. So always state the youth justice statutory aim explicitly: preventing offending and reoffending. Show who must regard it, all people who are involved in criminal justice system, be it police or judge. Always mention the welfare principle from section 44 CYPA 1933. Explain how it influences disposal decisions. Identify age at commencement of proceeding, not offense state. Age at commencement determines jurisdiction and available disposals. For turning 18, distinguish before and after commencement. Before means mandatory remission to adult court, after means discretionary remission, and if retained, youth disposal remains available. So youth court privacy and reporting restrictions are frequently tested. Know who can attend and what media restrictions apply. Referral order, mandatory conditions are common trap. Many of us forget all three must be present. First offense, guilty plea, non-custodial, suitable. For YRO check availability bars, existing compulsory referral order or grant YRO, prevent new YRO. DTO requirements are strict. Custodial threshold, explanation by alternatives, insufficient age restriction with persistence for 12 to 14 years old and banded terms only. Crown Court youth cases involve remission consideration, usually remit to youth court for sentence unless undesirable. For cost and financial order, apply the priority order correctly. Compensation has statutory priority over fines. If means are insufficient for both, compensation comes first. Compensation orders must be prioritized. Court must justify refusal to order compensation if the offense caused loss or damage. So the victim surcharge is mandatory, but can be reduced if the defendant's means are insufficient. It cannot be waived entirely without means justification. So legal aid rules, police station advice is free for everyone. Under 18 automatically satisfy mean and interest test for representation order, but application must still be made. So your exam trigger, age, forum, disposal, financial priority, hit all four elements. Every youth justice answer should identify age category, which court has jurisdiction, what disposal is appropriate, and how financial orders are prioritized. And I wish you all the best. I hope this makes sense and you pretty much understood it. If you didn't, go through this session again and it will explain you a lot. So if you like this video, hit the subscribe button and share it with your friends to prepare for SQE in an effective manner. I wish you all the best. Ta-da!